I hope you can hear me clearly. I'm quite honored to be among the esteemed faculty at LTIC. When Joanne Fishman, who's also on the faculty, my colleague, reached out with the opportunity to support this, I was really excited. It's something that I wish I had the opportunity to kind of go through a program like this before I moved into the tech space. But I guess in many ways, sometimes we do learn by doing. Maybe just a brief introduction of who I am and a little bit of my background before I give a teaser of what the course content would look like on cloud contracts. So I'm Otilia Phiri. I'm originally from Zimbabwe. I studied law in South Africa, and then moved to Dubai, where I probably spent the predominant part of my legal career, working in a mix of infrastructure development before I moved into the tech space. I started out with Nokia probably around 2012, prior to the acquisition by Microsoft, and that's how I landed up at Microsoft and have been with them now 6 going on 7 years, working in the capacity of commercial attorney. My work is transactional by nature. I thoroughly enjoy it. And that's part of the motivation behind the content for the cloud contract session. The idea here is to introduce in-house lawyers or law firms and practitioners, or anyone who might be interested actually, in what are some of the essentials you see in cloud contracts. And it's not so much just about cloud contracts as it is getting an understanding of when you're procuring emerging technologies, what are some of the new risks that maybe you might not have, that you might not contemplate in your normal commercial transactions? What are some of the areas you would focus on or negotiate in those type of deals? So the introductory bit would really just be to level set, get a clear understanding of what is the cloud, which would help frame an understanding of what are the shared responsibility between a cloud service provider and the end customer itself. And then walk into what are some of the essentials in the contract we see, or what are some of those, the commonly negotiated terms, whether it's terms around limitation of liability, data protection and security have become quite key. Given how intrinsic cloud is becoming to companies and their business processes, there's also questions around exit or termination, how data is retained or deleted if they move out. There's often as well negotiations around indemnities, particularly in the context of if there is a breach, and typically in security breaches. So the idea is to walk over some of those and perhaps also include a bit of a mock negotiation of terms based on our framework of cloud services terms, which are actually publicly available. But we thought it would be a great opportunity as well to walk through, what that actually looks like in practice day to day for people practicing within this space. And I'll probably end by saying this. I think this is a great opportunity for anyone who's really, I get a lot of people ping me, like, how do I get into the tech space? How do I get a better understanding of tech? And I think this is a great opportunity for anyone who has been trying to scale up on technology, trying to understand some of the legal concepts within the space, trying to understand how technology will impact the practice of the law otherwise, and also just scale up. And I'm looking forward to the other sessions as well, equal as much. And if there's no questions, I will park there.